I saw a video recently from another creator who asked a question that I thought was interesting. She said that in her parenting plan, her husband's attorney had drafted a provision about when the kids get older and don't necessarily want to follow the parenting plan and go back and forth on parenting time exchanges and how they were going to be flexible about it. But now that the kids are older, a few years on, later on down the line, the kids don't want to go to dad's. Now dad's upset about it, and the attorney is arguing against the language that she put in the parenting plan herself. And the creator was asking, well, how can she do this? How can she draft this language and then, get her way, ultimately not even uphold the language that she drafted and put into the agreement on her own accord, not even as a result of negotiations, but something that they put in kind of on their own. And the answer is because though it might look like attorneys have a lot of power, and in some ways we do, because we're able to draft these provisions and we try to help guide people through these complex situations, and we make arguments in front of the court about it, the reality is that every family law case, if it's litigated, comes down to what the judge decides. And just like people in every other profession, there are good judges and there are bad judges. And there are judges who have a bad day. There are judges who develop a prejudice against one side or the other and then continue to make decisions based on those prejudices throughout. And ultimately, it is the judge's decision whether the language even survives. Provisions from agreements get struck down all the time. So even though this attorney put that in there, even though she is then arguing against her own words, that can happen, not because the attorney did something sketchy necessarily. I mean, I wasn't on this case. I wasn't in the courtroom. I didn't see what happened. But ultimately, it's the judge who holds the power, and it's the judge that makes the decisions about what happens. And she can argue against the provisions that she drafted, especially a few years down the line as the circumstances have changed and as the situation maybe warrants it. And it's not to say that even that couldn't be valid depending on the facts. It could be. It could be. Things change and change profoundly. And ultimately, the standard in a custody case is the best interest of the child. So the courts often give a broad degree of latitude to the attorneys in bringing matters before the court if they believe that it's in the child's best interest that the judge hear it. So ultimately, that's what happened. And it's the judges who have the power to make these decisions, unfortunately, as it turns out in this case.